The Kentucky Small Business Development Center is a statewide, nationally accredited program that provides no-cost, confidential business coaching and training services. Whether you're just getting started or are ready to expand, we have the tools, resources, and expertise to help you succeed. We're part of a national network, America's SBDC, with over 1,000 centers across the nation. To learn more about how the Kentucky SBDC can serve you, please visit KentuckySBDC.com or email us at info@KentuckySBDC.com. You can also reach us by calling 888-414-7232. Thank you for joining today's webinar. The chat feature is available for you to ask questions and interact with today's speaker. Please take a moment to introduce yourself and where you are watching from today.
Welcome, everybody, to another Wednesday webinar. Thank you for joining us today. I'm Dave Etka, and I'm the director here at the Louisville Center. So again, if you look to the right of your screen there, you'll see the chat feature. And if you have any questions for our presenters as we go forward or comments, just put them in there and we'll get to them at the end. And just to test that everything's working, you can hear me loud and clear. Go ahead and do me a favor. Give us your name, say hello, and tell us where you're joining us from. It's always great to hear where everybody is joining from. We've had people from all over the country and all over the world, so it's always exciting to see where you're at today. So welcome, everybody. We have a great couple of guests today. Something that we've been thinking about here at the SBDC a lot is how clients negotiate different parts of their business, because every day is a negotiation in business. And I want to thank our two guests, Michael McGee and Michael Holtz from Dentons, Bingham and Greenbaum law firm here in Louisville. Dentons is the largest law firm in the world, internationally known. They have a world of experience, and if there's anything that these guys do every day is negotiate, and I knew they can have plenty of tricks and tips to share with us, and I hope you guys will enjoy this as well. So welcome, Michael. And Michael, I'm just going to turn things over to you and let you guys jump on in and get started, and we'll learn a little bit about negotiations today.
All right. Well, thank you very much, David, and thank you, everyone, for joining us today. Michael and I are both really pleased to be talking to you. As David mentioned, I'm Michael Holtz. Michael McGee and I are both corporate and transactional attorneys at Dentons, Bingham, Greenbaum. My work primarily is with manufacturers, distillers, but I also do work for a lot of small and mid-sized companies. A good portion of my practice is true M&A or mergers and acquisitions work. So the sale of a family company, the expansion of a growing business. But in terms of volume, most of what I deal with is sort of day-to-day needs of my clients. Drafting, reviewing, revising short agreements, terms and conditions, leases, things like that. So in that capacity, my role is either negotiating directly with the lawyers on the other side, or giving advice to my clients that they can then use and be prepared to negotiate. So we want to use our time today to share some of our insight into the negotiation process and give you a few areas of practical advice to use in your negotiations. So I'll start with an overview of how negotiations happen from our perspective, and then some of the trends we've seen in those discussions. Michael McGee will talk about the importance of preparation research, as well as some key considerations and tips for when you're at the negotiation table. And then finally, we'll go through 3 or 4 practical examples of negotiations of key agreements that we see with customers, suppliers, and other third parties. So the framework. When I think about what to expect in negotiating for clients, there are really 3 interrelated factors. The first is the transaction itself. For major transactions like buying or selling a business or sort of a multi-property, decades-long lease, the talks can go on for weeks and sometimes months. And that's really the case when you have a purchase price that depends on the performance of the business. So I'll give you a quick example. Back in early 2016, I was pulled in on a deal where we represent the seller, and the transaction took 2 years to actually get signed, constant negotiations. So in 2018, it closed. And to this day, the parties are still sort of performing on that contract, and likely will do so for several years. So these negotiations sometimes are quick, and sometimes they just are ongoing. Now, on the other side of that coin, if the purchase price is already determined at the beginning, I found that means that the parties are usually eager to make the deal happen. So your conversations are friendly and to the point. An example there, about a month ago, we closed a pretty sizable deal where the first thing the parties agreed on was how they were going to determine the purchase price. So there was no earn out based on performance, no holdback of any of the money. So these talks, the talks that happened around the time of closing were pretty friendly. I think the biggest thing we negotiated at that point was how to divvy up the last utility bills for the month. But purchase price isn't everything. So even a small deal can involve sort of drawn out negotiations. This is, for me, it's true when if the deal is something that's, that scares lawyers. If it involves technology or IP, it's something that can be that can be a little contentious at times. But one thing I always try to remind myself is the importance of the relationship between my client and the other party. I'm not a litigator, so while the other side might be a competitor, so to speak, they're definitely not an adversary. So I remind myself it's important that they and my client need to remain on good terms, especially for future deals and in the life of the current deal we're working on. So the type of transaction really tells us who will be involved, and then how those negotiations will happen. For major transaction, they tend to be negotiated in one of two ways, either between the clients themselves with the lawyers hashing out the details, or between the lawyers using a set of expectations that the clients have given them. Now, there are benefits and drawbacks to each situation, but since the client is the decision maker, having them in the room can really streamline the process. Now, of course, the message can get distorted when it gets back to the lawyers, and not surprised when the lawyers get their hands on the documents. The agreement can look quite a bit different than what the client may have had a handshake about. For the more routine transactions, like a sale of goods or a one-off agreement, those negotiations are usually just between the two parties. For many clients, I'll review a contract, revise it, send the language to my client that they can then use in an email to send to the other side. So the lawyers are sort of left out of the exchange entirely, do the work in the background. We try to write something for the client that's in the client's voice. And it seems to be especially true when the other side is a much larger entity. So a good example there is a sales rep has authority to negotiate a price for a contract, but anything involving the fine details and the terms and the conditions have to go back to the in-house counsel. And then the methods. So even before the pandemic, at least for me, in-person negotiations were pretty rare. When they do occur now, they really seem to happen where the parties already know one another or have some sort of existing relationship, like renewing a lease or an employment contract. So now instead, the default usually is just exchanging drafts through emails. There's a good and bad to this. It does take away a lot of the gray areas, but it also sort of gets rid of the chance to make your case and learn what the other side is really after. You miss a lot of nuance when it's all done electronically, in my case. Another thing we see a lot is the sort of 1-2 punch of the phone call email. Now, it can be good because it can allow the lawyers to highlight what's really important. But it can also be a chance for what we call a red herring tactic. And I think Michael will probably get into that later. Just this week, I had a call from the opposing counsel on a deal I'm working on to give us a heads up about some changes that were coming our way. And what he told us was important, but we knew those changes were coming. He didn't tell us about a couple of changes they snuck into a few definitions that has really thrown a wrench into this thing. So it can be a good way to distract someone is with a phone call and divert their attention. But a savvy attorney on their side usually can pick that up. Just another point before I hand it over to Michael McGee. Don't assume that just because you're dealing with a larger or more established company, you have to accept all the proposed terms, especially in the initial draft of a contract. I know it's probably not a shock, but a lot of these large companies tend to have a suite of documents that are very much in their favor. So, I'm not saying you can negotiate with Apple on their terms of service, but even in light of some unequal bargaining positions or what you think are unequal, remember that you have something that they want, whether it's your business, your product, your expertise, and that can usually result in something in them being a reasonably rational actor. And there are always areas you can push back on that I know Mike will probably get into. One last example, I have a client in Kentucky that has a small manufacturing business, but his products are incredibly specialized. And they are one of the only companies, they might be the only company making this particular product. So his customers come from everywhere. A lot of them are multinational type outfits. And the buyer will come and give us a 25-page document of terms and conditions. And even though he's smaller, he's able to use his asset of having a special product to usually win most of the battles that we choose to fight. So just because you might be a small business does not mean that you lack the power to get what's necessary for your company and what's going to protect you legally. So I'll hand it over to Michael McGee.
All right. Thank you, Michael. Appreciate it.
Sure.
So just as a quick introduction, my name is Michael McGee. I'm a partner in the Louisville office of Dentons, Bingham, Greenbaum. Like Michael, I work with a lot of small businesses, and as a result of that, I think my practice has become pretty varied. I dabble in a lot of subject areas. So I do a lot of mergers and acquisitions work. Like Michael, I also have a pretty substantial commercial real estate practice. So work frequently with commercial real estate purchase and sale agreements, commercial leases, that sort of thing. I also have an IP related practice where I deal with copyrights, trademarks, and other soft IP matters, I'll call them. And I've developed over the course of my practice really a passion, and I've done quite a bit of in the area of software licensing, software development, SaaS or software as a service agreements. So work pretty frequently in that area as well. So just a quick overview of sort of the spaces that I play in. And really what I wanted to, I guess the first thing I wanted to address, as Michael pointed out, I think preparation is key in the course of any negotiation. So the first point that I wanted to underscore is it's really important that you know your subject matter. Being confident in the subject matter of the negotiation really allows you to project confidence, which is really important in a negotiation, particularly in a sort of face-to-face context. But people can pick up on the cues, like in a phone discussion as well. If you really don't know your stuff, you're faking it until you make it. It's important where you can to sort of generate knowledge of the subject matter at hand. And I'll skip ahead to one of the bullet points below. If you don't, have knowledge about a particular subject matter or particular subject, area that's subject to of the negotiation, it's important to involve the right people. So if you have someone who's familiar, say you're not familiar with software development, that sort of thing, and the negotiation involves software-related subject matter, you may want to involve if you have someone on your team who is familiar with that subject matter, who can really provide input on the matters being discussed. It's also important to involve people who are decision makers in the negotiation. If the proper people aren't involved, either at the meeting or on the phone call, it can make the negotiation unproductive because you're reserving everything for further decision by the decision maker who's not present. So important to have the right people present. Understand what's customary and what isn't. Understanding what is customary will help give you a baseline in making some of your initial offers. It will also help you assess whether the other side is being reasonable in what they're asking for. So, for example, in an M&A deal, which again I do quite a bit of, it's customary for a portion of the purchase price to be held in escrow to secure any indemnification obligations that might arise after the closing. So somewhere in the range of 5 to 10% would be customary, 5 to 10% of the purchase price, whereas 50% are not. So if I'm on the seller's side of the table in the negotiation, if the buyer comes with an initial proposal of 50% of the purchase price being held in escrow, I know that's not customary. I know I'm justified in pushing back pretty forcefully on that request. So again, sort of related to knowing your subject matter is also knowing what's customary in a particular situation. Next thing I've found is really useful is preparing an agenda, or it can even be a bullet point list of items to be discussed. And this goes back to making the negotiation as productive as possible. If you just show up with no agenda, no real talking points, the discussion can become pretty disjointed pretty quickly, which again, the whole point of getting together for a negotiation is to get the deal done, resolve any differences that the parties might have. So if I send out an agenda with some of my positions before the meeting, it gives the other side the ability to A, know what I want to talk about, and B, know sort of, again, my positions on the issues so they can develop their responses, their counter proposals. I find it makes the negotiation much more focused, much more productive. Another point, that's important to consider, and Michael sort of touched on this, is understanding who has the leverage. So leverage it's a pretty broad term. It can come in a lot of forms. I guess so. I'll just throw out a few that I'm used to seeing. One, I'll call it sort of leverage in terms of bargaining power. So Michael's right. If you're negotiating against Google or Amazon, Walmart, some other behemoth of a company, you may try to negotiate some of their standard terms and conditions. But a lot of times what you'll find, especially for some of the more standard contracts that those parties will present, is that they'll say, no, that this is what we always do. We don't really have any room for changes or revisions here. And they really use their size as and throw their weight around in resisting any changes to the document. So leverage in some instances can just come in the form of, the size of the counterparty. Timing also gives, parties some leverage in a lot of situations. If you are up against a deadline under a contract, so to speak, the contract is slated to terminate, or the closing is supposed to have occurred by a date that's, that's happening tomorrow, there's really a lot of pressure on both sides to get the deal done. And that can help you work through it, especially some of the less material issues, is using that timing to your advantage, and really getting down to brass tacks and hopefully resolving the few remaining material issues. There are, monetary incentives and disincentives also give some leverage. So what I'm used to seeing a lot in my commercial real estate practice is, a buyer will get a property under contract. They'll do all sorts of inspections of the property. So they'll do environmental inspections, physical inspections. They'll review the title. They'll get a survey. They'll review the survey. Invariably, some sort of issue comes up in the course of due diligence. And a lot of times the way that's resolved is the buyer will ask for some sort of monetary concession from the seller, or a reduction to the purchase price, something along those lines. So, rather than simply walking away from the deal, throwing their hands up, typically you are able to get the seller to move on those types of requests, as long as you're being, reasonable about it. You're not over asking in terms of, again, for instance, a reduction to the purchase price. It's, as Michael mentioned, usually the seller has their eye on the prize. They want the purchase price for the property at the end of the day. They're probably willing to give you reasonable concessions in order to get to that closing table and get the money in their pocket. So knowing that they have sort of that financial disincentive to walk away from the deal, just as an example in that scenario, gives the buyer some leverage just from a purely monetary perspective. So leverage can come in that form as well. Okay, so the next set of items I wanted to run through are things I've found, important to keep in mind when you're actually taking part in the negotiation. And one thing I didn't put on the slide, but I do want to briefly mention, and Michael sort of touched on this, but I just wanted to underscore it. Where you can, for relatively insignificant issues, immaterial issues, it's okay, it's useful, it's productive to negotiate those, just flipping emails back and forth. But when you get to the significant issues in any deal document, I find it's really much more productive. You get a much quicker resolution if you're negotiating those either in person or over the phone. What I've found is when you're trying to negotiate those key issues on email, it's a lot easier to be snarky over email. It's a lot easier to dig in your feet over email. You just don't have that personal factor, that personal engagement factor. So again, when you get down to the significant issues, I would really implore you to have that negotiation either in person, over Zoom, over the phone, whatever the most convenient method is, because I really do think that is the most productive way of conducting a negotiation, at least for the significant issues. So first thing on the slide, it's asking who makes the first offer. I would say there are definite pros to you making the first offer. There are some potential cons or drawbacks to making the first offer, but I think as a general rule of thumb, especially on some of the key business issues like price, term of the agreement, that sort of thing, it generally makes sense for you to make the first offer. And a lot of you have probably heard the term anchoring, especially on monetary provisions. It allows you sort of to anchor the negotiation around a specific amount. And usually you're going to end up relatively close to where you want to be by making that first offer rather than responding to an offer from the other side. I guess the one scenario where you may think about letting the other side make a first offer is where you're completely unsure as to what they may be willing to give you on a particular point. So, say I'm selling a house, I have no idea what someone may be willing to offer for it. You may want the buyer to name the price rather than setting it yourself, and potentially having it backfire on you by making the first offer, and that the buyer perhaps maybe be willing to offer more than the number you gave them. So really, I guess the only instance where I would suggest not making the first offer is, again, in a scenario where you just really, that there's some uncertainty surrounding the term. That may be a scenario where you let the other side make the first offer. Michael also mentioned this sort of red herring concept earlier, and this is something I like to use pretty frequently. So when I'm referring to a red herring in the context of a negotiation, it's a tactic where a party will act like a particular issue is really important to them. Perhaps it's even a deal breaker to them, but that you ultimately end up letting go as a concession in the hopes that you'll get a concession from the other side on an issue that's really, in reality, more important to you. So to give you an example, just from that I encountered yesterday, I'm working on an M&A deal where I'm representing the seller of a business. In most M&A deals, there's a concept in the purchase agreement where the seller's liability, their monetary liability for indemnification after the closing, is capped at a specific dollar amount. And that issue was supremely important to my client. There was another issue that was, open, still needed to be resolved, that my client it was important to them, but not quite as important as that cap on the indemnity. So we had a phone call with the other side. We spent probably 10, 15 minutes negotiating the other issue, really raising a fit about it, really digging in our heels, and then, sort of let that discussion go. Later on in the discussion, determined that was something we could give them. So we did. And in exchange, the buyer immediately came down on the cap. So it's sort of, it's a quid pro quo kind of tactic, but really you're giving up something that's not as valuable to you in exchange for something that is more valuable. So I find that very useful. That being said, it's possible to overuse this tactic. I'm thinking back to another deal that I did late last year. It was another sell-side M&A deal. And I can't tell you how many times the buyer's counsel in the course of negotiations said, my client never agrees to this. This is a deal breaker. We're never going to move on this. And time again, they folded and conceded on the issues. That made, we fell for the trick, I guess, maybe at first, as they kept using that tactic, in folding on issue after issue. It made them less creditworthy or believable to us, and sort of really harmed their negotiating position from our perspective. So the red herring tactic, it's important, it's very useful. Just don't overuse it, because it really can backfire, and I've seen it happen before. Another thing I've found that's very useful, very important, is you can argue back and forth over numbers or the issue at hand, but what I've found is very useful is rather than just bickering over the specific point, is really trying to get to the bottom of what is driving the other side's concern there. So literally ask the question, why are you making this request? What is your concern on this particular issue? And I found that really can help you come up with some creative solutions that gives the other side the comfort or the assurance that they want, while also protecting your interest and not overgiving on a particular issue. Another thing I've found is useful, keep it cool, keep it cordial. People really tend to shut down when a negotiation turns into a shouting match or an argument. Things really, flow much more smoothly. Deals get done much more quickly when the parties are working amicably. They're keeping things pleasant. Yes, you may have disagreement on a particular point, and that's fine. But keeping your cool, again, I've found that really helps facilitate things in the long run, and it gets you goodwill, with the other side, which can help you get concessions on points that are important to you. The other thing noted here, it's okay to table when at the table. Like I said, it's important to have all your decision makers on the phone or in the room when the meeting is happening. That doesn't always happen, or there may be scenarios where you just may need to give a particular issue some thought before you offer confirmation or a response to the other side. So, the point of a negotiation is to get things done, to get a deal done. But it's okay to table an issue if it's really something you need some time to think about, or if you need to discuss it, with your business partner, your attorney, your accountant, whoever needs to weigh in on that particular issue. So perfectly acceptable to do that. And then lastly, just keep the big picture in mind. It's very easy to get frustrated about a particular issue, to get worked up over a particular issue. Very, very rarely is an issue so big, so insurmountable that it's worth walking away from the deal about. So I was, just keeping the eyes on the prize, so to speak, keeping your eyes on the intended end result of the deal or transaction, I think is really important, and it just helps you perhaps, or all parties, from digging their heels in on issues that ultimately are not deal breakers, or not fundamental or that significant to the deal. So always good, again, to keep the big picture in mind. So this next set of slides, I talked earlier about it's important to understand what's customary in a particular agreement, or with respect to a particular subject matter or transaction. So what Michael and I thought would be useful here is just run through a few standard documents that a lot of small businesses routinely encounter, and just point out some issues that are of significance, of concern to a lot of small businesses, and then just sort of point you in the direction of what may be customary there, what's acceptable to push back on, and what you may keep in mind as you in this first instance enter into a negotiation with a landlord. So this first slide does deal with lease agreements. Certainly there are instances where a business owns the real estate, where it operates as business. By and large, we find that our clients, our small business clients, enter into leases with third-party landlords. So for that reason, I'm going to sort of, at least on this particular subject or type of agreement, focus more on it from a tenant's perspective. So the first bullet point here, it's really important to pick the form of lease if you can. That really can dictate, going back to the anchoring effect, it can dictate the end result and where you end up in the negotiation. Large institutional landlords, larger landlords are more likely to insist on using their own forms of leases, which probably are going to be quite landlord friendly. But if you're dealing with a smaller landlord that it just has one or two commercial properties, they may be willing to let you come up with the first draft, and that gives you the opportunity to make it more tenant friendly, include some things that are favorable to you. So, again, it may not be possible, especially if you're dealing with a larger landlord, an institutional landlord. But if you can pick the form, if you can prepare the first draft or have it prepared on your behalf, that's always a good thing. Again, just from a sort of an anchoring perspective. So this is by no means an exhaustive list of things to keep in mind as you negotiate a lease. Leases are very complicated documents. There's all sorts of issues that come up and the parties typically need to work through. But these are some of the big ticket issues. So first one is build out obligations and payment. So when you are when you're entering into a lease or a business is, typically there's going to be some sort of build out or renovation to the building or the space that needs to be done to allow your business to operate or properly operate from the space. It's important to understand whether those, and that process needs to be clearly spelled out in the lease. It's important to understand what the lease says in terms of who is responsible for doing the build out and who's paying for the build out. So a lot of times the landlord will make a contribution towards the build out, and that's something that's perfectly reasonable to ask for. If they are making a contribution towards the build out, it would not be unheard of for them to take the lead on that. But certainly if they are, you want to make sure that there is a process, very specific process, that gives you the ability to hopefully dictate, review, and approve plans and specs for the build out, and then do a final walkthrough once the build out is completed. So something to keep in mind there, again, just understanding who's responsible for the work, who's responsible for payment, and then just sort of the review and approval process, very important as well. Rent escalation and adjustment is the next point we have here. So especially if it's a longer term lease, if there are renewal terms involved, almost always the rent is going to increase at some point over the term of the lease. So from your perspective as a business operator, you're most likely going to want predictability there. So what I would suggest being on the lookout for with this type of provision is making sure that the rent is increasing using a specific percentage. A lot of times what a landlord will try to do is tie the rent escalation either to some sort of inflation index, so the CPI, or using some sort of fair market rent process, which can become quite complicated. It's also subjective, and could get the landlord the ability to raise rent, unduly high. So again, if you can get certainty on that point by including a specific percentage increase, that's something I would certainly fight for. Something also to be on the lookout for, and unless you're leasing the building on a triple net basis, we call it, which is when the tenant is responsible for all taxes, all insurance, and all operating expenses of the building. Usually the landlord is going to pass along at least a portion of its operating costs in the form of, it's often called CAM, or operating expenses. And that's fair, right? For the landlord to pass along some of its operating costs for the building or the property to you, because you're benefiting from it. But what we see is a lot of times landlords will try to overreach a bit, include things that shouldn't be included, like debt payments, interest payments, uncapped capital expenditures, things of that nature. And there are things that are typically and customarily passed along to tenants. There are things that are not. So it's important that you understand what a landlord can pass along. And engage in an attorney possibly who's familiar with what's customary passed along and what's not, and know where you can push back. Also important to understand maintenance, repair, and replacement obligations. Again, particularly in a situation where it's not a triple net lease, it's perfectly reasonable for you as the tenant to try to push off as much as possible on the landlord in terms of maintenance and repair obligations, and that's especially true for a shorter term lease. So know that you have some leverage there. It's customary for the landlord to bear, at least a decent portion of those obligations. Insurance, it's also important to understand what's customary. Perfectly reasonable for a landlord, for instance, to request that you carry liability insurance, but it's not customary for them to ask you to carry, $50 million worth of liability coverage. That would be an absurdly high request. Something in the ballpark of 1 to 3 million is much more common. So, knowing what amounts are customary as well as types of insurance that are customary, important as you're in the midst of any lease negotiation with the landlord. Indemnification, limitation of liability, we have listed here as well. Again, in a situation where, for instance, you're not the only occupant of the building, you should know that you have the right. It would not be unreasonable for you to request that the landlord indemnify you, protect you against liability from, for instance, damages that or liabilities or lawsuits that are caused by other tenants of the building. That's not a risk that the landlord should ask you to bear. So know that you can push back there. A couple final issues to be on the lookout for. The second to last one here, so the continuous operation and force majeure, especially important during the pandemic era. What I always suggest my clients who are tenants to be on the lookout for here, make sure that you don't have an obligation to operate your business continuously from the premises. And if you do, at least make sure that is not something that gives the landlord the ability to terminate the lease. We've seen time and time again, businesses are forced to or elect to have their workforce, their employees work from home. They're not present in their traditional physical office location. So just keep an eye out for that issue, and try to get the landlord to agree to not giving them grounds to boot you out of the premises, again, if you're not continuously operating. And then last item is assignment and subletting. A lot of landlords will they'll try to place pretty tight strings on your ability to assign the lease. It is very common, very customary for you to at least ask for some instances where you can assign the lease without the landlord's consent. A lot of times that's either to an affiliate or perhaps more noteworthy is an assignment in connection with the sale of your business. You don't want a landlord to have veto power over a potential business transaction, business sale down the road. So it's important to get those carved out if you can, save yourself some headaches down the road. Next item, and I know we're butting up close to the end of the hour here, so I want to make sure Michael has time to get through his piece. So I may skip past a couple of these. So another document we wanted to talk about were purchase agreements, and in this context, I guess we're thinking about purchase agreements for the purchase of supplies, equipment, products, that sort of thing, and not a purchase agreement for real estate or for a business. So first bullet point we wanted to underscore here, these may or may not be negotiable. If it's just a one-off purchase, for instance, from a supplier that you don't think you'll have a long-term relationship with, not very likely to, or it's probably less likely that the other side, that the supplier is going to be willing to negotiate or budge on its standard terms. Conversely, if this is going to be a long-term agreement, or you expect to have a long-term relationship with the seller or the supplier, as the case may be, they may in fact be willing to negotiate on some of at least the key issues, give you some concessions on some areas, again, just to earn your long-term business. So it's sort of a deal by deal situation on whether these are negotiable. Certainly it doesn't hurt to ask, in any case. Things to be on the lookout here, and I'll just sort of breeze through these pretty quickly. Obviously, how long the relationship lasts, whether it is an exclusive supply agreement. So as a purchaser, you probably don't want to be locked in to using a specific supplier. You want to have the ability to go out and purchase goods from other suppliers. So, and that's something you can push back on, and want you to keep an eye out for. Fulfillment, delivery, inspection, acceptance. I guess the key thing here is, a couple key things. Making clear that it's delineated in the agreement when risk of loss passes, in who's liable for or responsible for damage to the goods in transit. Another important thing is inspection and acceptance rights. So a lot of suppliers, or some suppliers, may try to get you to agree that their obligations are done when they deliver the goods to you. You should have, and this is perfectly reasonable to request, the right to inspect any products that have been delivered, to reject any goods that are either damaged or missing or otherwise non-conforming, and that the supplier, the manufacturer, either refund you or provide replacements for those defective goods. So important to keep an eye out there. That's something that routinely parties will negotiate. And then lastly, I guess the other big thing I'd like to underscore, warranties. Again, if you're a purchaser of a product, a supply, you would like the manufacturer to stand behind their product, at least for some reasonable period of times. A lot of times that's 1 year. So just, again, where you're dealing with physical goods and you're the buyer, important that the agreement includes some sort of warranty process for how those claims are handled, that gives you recourse if something goes wrong with the product down the line. I think I'll kick it over to Michael.
Thanks, Michael. The first type of agreement that I want to talk about quickly here, confidentiality agreements. And these, as you all probably know, they're pretty much universal in a lot of situations you come across in business. So we see them at the outset of any deal, large or small. And I guess it's just something to anticipate is going to be coming your way. If you can, try to develop your own form. They aren't terribly complex or lengthy. They don't need to be lengthy. They can be 2 pages. You can pretty much cover everything you need to. But they're always a great idea to protect not only your business, but any confidential information that you have that's been entrusted to you. So if your company's under an obligation, it's just a good way to protect that information as well. They can be standalone or they can be incorporated into another larger agreement, like a employment contract or a supply agreement. And they can be one way or two way or mutual. So if a client asks us to review, or a client is asked to sign an agreement that's one-sided, the first thing I recommend is that they make it apply to the other party. It's really difficult for the other side to not give you the same benefit of protecting your information. Now, in terms of protecting the information, these agreements not only let you protect physical documents, but also information that someone might learn from you or about your business by just having a relationship with your company, whether they're an employee, a contractor, a potential customer. And it's really important at the early stages of a business when intellectual property and trade secrets are being developed and discussed, and you have consultants coming in. That's the time to really protect a very valuable asset to your business. In terms of negotiating the agreement itself, a few things to watch for. The first is make sure you are being asked that what you're being asked to protect doesn't include information that you already have a right to know or that you have developed independently of the information that's been entrusted to you, or just things that are publicly available. The second point, for some regulated businesses, distilled spirits, tobacco, things like that, where there's a greater chance of government investigation or public scrutiny, make sure that as the disclosing party that you still have some say in what might be turned over. Just because a subpoena has been issued doesn't mean that the other side has to give over your information. You really want to make sure that you're part of that process. And then finally, make sure that the penalties of disclosure are appropriate. We see some confidentiality agreements that are drafted with a survival period that goes on indefinitely or years after the relationship has ended. So don't be afraid to push back on the length of the agreement or the level of exposure to your company. And then finally, non-compete agreements, and this is somewhat related to non-disclosure in that it's another place that these confidentiality provisions appear, alongside other restrictive covenants. As an employer, two big things to ensure at the outset. So if there's an existing agreement that applied to an employee while they were perhaps like in a lower role at the company, and it was more narrowly tailored to what they did in that job, or it's just outdated, you want to make sure that the new document supersedes the old one, or that the old one isn't going to be, for some reason, trump the new document. And then second, at least in Kentucky, we have a requirement that some amount of additional payment is required for a non-compete to be valid. So an employee's continued employment or continued right to earn paychecks is not enough. You have to have some amount, and it doesn't have to be large. It can be $100 usually, but that'll make it effective. And then, as with confidentiality agreements and other agreements, definitions are really important. And for me, and I'm sure Michael, we negotiate in these really fine details. One area that's often heavily scrutinized and highly negotiated is just the definition of what is competition, what is a competing business, and that that's important to usually to a high-level executive that might go work for a competitor versus they might go work for a supplier. So you need to be on the lookout for things like that. Case law or previous litigation usually dictates what's reasonable in terms of the area where an employee's not allowed to compete, and for how long that can go on. There's a certain number of years that the Kentucky courts have allowed for certain types of jobs where they're not allowed to compete. But with the pandemic and the ability to do your job, a lot of jobs from a lot of places, there is some uncertainty now in the case law. So we'll see how that plays out. And then finally, depending on which side of the table you're on, pay attention to indemnification language, which I know Michael talked about. That's another area where the words are very important. So if you're on the hook for damages that relate to a breach, it's a lot different from those that result from the breach. So it's really important to look at that to see how large of a net is being cast and how much you're on the hook for. So that's it for our slides, and we'd love to hear any questions or comments or anything like that.
Thank you, Michael. And Michael, that was awesome. We do have some questions. So let me get right to Sandra. So Sandra has a dental lab, and she'd like to know if you could give her an example where you had helped a manufacturer of medical devices win-win contract with dental chain or dental groups, local or out of state.
Michael, I've done work with dentists in their practices, not with suppliers for.
Mm-hmm.
Yeah, I know I've done some supply agreements on like just the general scientific lab equipment side. I can't recall any instance where I've put that in the context of practice, and I too have done quite a bit of work for dental practices. Actually, just help someone with a lease that ran a dental practice, but not thinking of any specific.
What about with your manufacturing clients? Because that's similar. Like, what type of contracts or what do you watch for when you're working with your manufacturers and they're negotiating something with with one of their customers, I guess?
Well, so what I look for usually has to do with liability, with what the manufacturer liability is for the product after a certain period of time. So we have the one I'm thinking of is equipment manufacturing, and it's important to my client that if there's any alteration or adjustment made to the equipment, that sort of severs the liability to my client. So it's looking at how long you're going to be on the hook, and what types of things can essentially relieve you of your obligations to the customer. And so related to that is inspection, which I know Michael McGee talked about, but making sure that what you've sent as the supplier is, when they open the box, that they've confirmed that it's what you're sending, so that there's no room for any debate later about well, it was in good shape when you got it, and that sort of thing.
Thanks. Yeah. Here's one from Omar. He says, thanks for the great webinar, by the way. He says, in the case of a new startup, how to sign a long-term lease with a landlord, which is critical in his case, but at the same time cap the risk of this startup failing and being committed to a long-term lease. And that's something that when you were talking about that, Michael, sometimes a landlord will stick in a personal guarantee in the lease as well.
Exactly, and that's not a point that was addressed on that slide, but I would say that is by far the biggest thing I would be on the lookout for, is understanding whether the landlord is asking for a personal guarantee from you as the owners. And I don't know if you have business partners, but for many of your partners, that's by far the easiest way that the landlord's going to be able to have personal recourse against you as the business owner. So I would certainly be on the lookout for that. There are ways that you can, if the landlord insists on a personal guarantee, there are various ways you can cap your monetary liability at a specific amount. And there's many ways to do that. But that's certainly something to keep an eye on.
One real quick, Dave, one thing to also keep in mind is that you have the ability to try to assign the lease. Like if the business is going under, ask the landlord to be reasonable and allow you to assign it to another capable tenant. And even if that's not possible, put something in the lease that says the landlord has an obligation to mitigate damages. It's implied in some states, but it's just good to have it in there so that you're not still paying for something you're not using, and the landlord can still has a tenant lined up, but it's not taking their money. So
what do you guys think about using a short initial term and then adding options on the back? Could you comment on that?
Yeah. I've typically suggested that, and that's worked out well for some of my clients previously. If you can keep the initial term relatively short, say you're probably not going to get a year, but maybe 2 or 3 years, at least that gives you the ability, if things, God forbid, do go south and you've got to back out of the lease, that gives you, much less monetary exposure than say going with a 5 or 10 year initial term with shorter renewal options. So that's a great point. Especially for a startup, keep that initial term as short as you can, just so there is, potential reduction in monetary exposure if things do go south.
And be willing to trade maybe a slightly higher base rent in that initial period for a shorter initial term. It's better to take the hit up front than to have it continue on for longer.
Yeah. Here's my question. I've never done this, but it's when we were talking, I was thinking about it. But have you guys? Let's just say you have an initial term and 2 options, and when the initial term's over and you're at the decision period on the first option, have you guys ever retraded the terms on the option, or are you stuck? Is that a tactic?
I actually, Dave, I saw that it's going on right now, and it's happening by the landlord who's trying to now tie the renewal period rent. He's trying to insert an escalator because he's spooked by all the inflation talk. So if it can happen on that side, it can certainly happen on the tenant side. Okay,
cool. Here's something from Peggy, and this one's for you, Michael. That's easy to say because you're both named Michael. Peggy asks, how do you register or copyright prints or designs on a T-shirt?
On a T-shirt, okay. So copyright, you have copyright rights inherently under federal law the moment you fix it to that product. But really the rights you get from an unregistered copyright are not all that substantial. So there is a process under the statute where you can federally register a copyright. It's a relatively simple process. The filing fees are pretty nominal, and I should know them off the top of my head. They're under $100 for certain for an application, and it gives you a lot of sticks you can throw around if there are you come across a third party that's infringing on your rights. Including enhanced damages, reimbursement of attorney's fees if you have to engage an attorney to go after the infringer. So yes, certainly there is a process available. It's relatively cost effective and it gives you a lot of benefits.
And so that goes with your your logo design as well.
Perhaps. It really depends on the context in which you're using a logo. So, for example, a design on a T-shirt is probably something that would be subject to a copyright application. But conversely, a logo for your business that you're, for instance, you've got up on a sign in front of your office or on your website, that's probably a service mark.
Mhm.
And again, it's use specific, context specific, but there is certainly a process for registering your service marks and trademarks on a federal level as well. So.
Okay. How important is it to do that? You know, if you're just let's just say you're a small business, just operating here in Louisville, for example, and you know that type of protection is a national protection. Is that super important?
That's a great question. If you are solely operating in the local market, you've really got no eye towards expanding, throughout the region or expanding nationally. You probably don't need to federally register your trademark or your service mark. There are, in the U.S. is kind of an odd bird in this sense, but you do get rights in your trademark or service mark just by virtue of using it in commerce, even if you don't register it. So again, if you're just using it in the local market, you may consider just not doing a federal application. That said, a federal application it's a little more expensive than a copyright application. It's around $300 per class of goods or services you've got listed in your application, and that's the government filing fee. It does give you a lot in terms of substantive protection, like you said, Dave. Even if you're only using locally, for instance, once you get your registration, you've got constructive nationwide use of your mark. So if you come across, you're located in Kentucky, but you come across someone in Hawaii who's using a similar name or a similar logo, you can go after them for infringement, even if you've never even entered that market. So it can be a pretty valuable tool. It offers a lot of benefits. Like I said, it's a little more costly than a copyright application, but the costs aren't exorbitant either. So it's a great option for business owners for sure.
Yeah. Thank you. I think that's all the questions we have. This has been awesome. This has been great. I've learned so much today, and I really appreciate you guys taking time out of your day. I know you guys are super busy, so I really appreciate you sharing with everybody today. So thank you, Michael, and thank you too, Michael.
Of course. Thanks for having us.
So we, just a reminder, we'll send you a recording of today's webinar. The slides are there to download right now, or we'll attach them later on today. And then is it okay if we share your contact info for the folks if they have a question or two?
Absolutely.
Yeah.
Okay. Excellent. Well, thanks, everybody. Thanks, Michael, and we'll see you guys next Wednesday. Thanks for joining us today.
Thank you.
Thanks.
Thank you for joining today's webinar. At the Kentucky SBDC, we know small businesses are the heart of our economy. That's why our goal is to help business owners start, grow, and succeed in Kentucky. Find out more about how our no-cost business coaching, training, and resources can help your business. Visit us at KentuckySBDC.com.